Now, the North Gauteng High Court has granted an order to the ANC paving the way for the party to sue former Eskom CEO André Ruyter. Comes after he leveled corruption allegations against government officials during an interview in February. For more on this, we're joined now by legal analyst Mpumelelo Zikalala. Good to have you, and thank you very much for coming on tonight on In Focus. First, for me, what struck me is this wording that says the North Gauteng High Court is giving them permission, granting them an order yesterday. What does that actually mean?
Just remember that you have the rules of court that state how a person should be served with court papers. Now, they say the sheriff, if you're in South Africa, will come to your house, give you that particular court documents in which you need to respond to, and that is taken as effective service having been done. Now, in situations where you are not in the Republic of South Africa and the sheriff cannot come to you, you usually go to court and say to the court, or make an application and say, court, I'm trying to look for Mr. Ruyter, is not in South Africa. I would need to serve these legal documents upon him. Can you allow me to do something which is called substituted service? Then I would take my court papers to an embassy in the UK and wherever that he is staying, so that he can be served, so that he's perfectly notified that he is required on this date or on this type of notice to come back and respond to these legal allegations that I'm leveling against him. So the granting of the order simply means that the ANC has gone to court and stated that we need this substituted service to be effected. Can you give us an order to do that? We've tried all that we could to make sure that we're able to locate him, and we have failed, but we have reason to believe that if we serve our papers in the UK, in whatever part of the world that he's in, he'll have proper notification and come back to us.
Does the court then look at the legal allegations and the merits thereof at this particular point?
Not at all. It is simply purely on an administrative side. The only thing with the court is concerned with is he going to get enough or adequate notification that he's been required to answer in this particular location, in this particular legal matter. So the merits are not even considered at all.
Does it matter whether they know or not where he is in Germany, if he is in Germany, or if they are speculating that he is in Germany? Because from what we know, he was feeling unsafe in the country, and this is the reason why he left.
No, not necessarily. So you see, in this instance, the court is simply going to state what you need to prove to the court as the applicant is that I've tried and I've searched all around South Africa and I can't find this particular individual, but I have reason to believe that he's in Germany. So can you allow me to serve this particular court paper in Germany? If I'm successful, then good for me. He'll be able to come back and respond. But if I'm not, I may have to come back and make another application to serve on a substitute service in another country in which I would believe that he's in. So they don't even look at the merits, whether are you really talking the truth when you're saying that he's in Germany or in any other country that you are referring to. So it is simply on an administrative basis and nothing more.
Yeah. It's a civil matter, is it not? I mean, defamation, that's essentially what it is. So tell us how you initiate that particular process. I suppose it's not the same as a criminal matter where the NPA has got to satisfy itself that we have a case and then therefore go ahead and sue. This one, if I feel aggrieved by you, I can just wake up tomorrow and say I'm suing you.
Definitely. And you can then do your papers and take them to court. And if I cannot get your attention because you're not in South Africa, that's when I apply for a substituted service. But if I then go to court, the onus of proof is then on me as the applicant. So in this case, the onus of proof is on the ANC to say that by uttering those words, you indeed defamed us, and what you are doing, you are encroaching on our rights, and you suffered some level of damages, either from a reputational point of view or on a financial point of view. So when we require some sort of reparation or being restored into a position we would have been in had it been you had not uttered those words that have defamed us. Now, in this case, I think the court will also look at the fact that, well, we are dealing with the African National Congress. It's a leading political party, and there may be some sort of jabs that can be accepted as being, even though not necessarily being true, but to a certain extent, you must take them as you go. So if there are any instances in which there should be his defense, whatever that Mr. Ruyter was saying is true, then the case for defamation that falls apart. But the person will be able to decide who's wrong and who's right in terms of the merits of the matter as the presiding officer, and it will depend on the case that has been mounted by the ANC to state that, yes, Mr. André Ruyter indeed defamed them.
Yeah. That's precisely what I wanted to ask. I mean, the ANC is probably called corrupt at least 100 times a day by some political party somewhere or some individual somewhere. It happens quite often. And one would say maybe they do it in parliament. Parties, they have parliamentary privilege and they can say that, so they are protected. But they say it even outside of parliament, where there is no parliamentary privilege. What are they trying to get at here?
There are two ways of looking at it. One is to say, even though people may say it, it does not mean that if I don't pursue those individuals legally, what they are doing is correct. It may be incorrect, just that I didn't take the decision of taking them to court and saying that you've defamed and you are dragging my good name through the mud. However, if they're going to engage on it now, the court certainly is not going to be blind in the process and the manner in which the ANC is in. So the court will always come back and say, let's look at the type of person that you are in this case, the African National Congress. You are a political party, you are in a political arena, you are going to have jabs which are thrown at you, you are going to have accusations which are going to be thrown at you. But look at the severity and the seriousness of what has been stated by you, the type of reparation and harm in which you have suffered. So from the side of Mr. Ruyter, certainly he's going to cite all those instances in which the ANC has been called corrupt. And he's going to say, tell me what sort of damages you've suffered when they called you corrupt, and where's the difference when I'm saying it is part of my freedom of speech, and I've stated what I've stated. Unless you're going to allege that I've broken a certain law, then we can come back and have another discussion. But on this one, I was simply exercising my freedom of speech, and part and parcel of that is that I'm going to throw jabs at you as the African National Congress, as a political party, as a party that is dealing within the public arena. So you must take it as it comes. That's the unfortunate nature of the type of space in which you are dealing.
How much weight does the statement, I don't know whether they made just the statement publicly or whether they sent any letter to André de Ruyter, but they said, you made the allegations. If you want to stand by your allegations, I'm paraphrasing here, go open a case if what you're saying is true. And if you don't, we are going to sue you. Is that good enough to say to the courts, well, we did warn him?
Not at all. But you must look at what are they trying to get at by saying open up a case. If you open up a case, let's take a step back. If you are saying to Mr. André de Ruyter, as the CEO of Eskom, you under the Public Finance Management Act, and you're obligated by law to go and signal and open up a case in instances where you believe that laws have been broken. So if we're going to accountable based on that, then the basis of our opening the case is going to be go and comply with whatever that you need to comply with. Failure to do that, there are certain offenses and penalties which are going to accrue to you. However, if you go against Mr. de Ruyter by saying that there are certain defamatory statements that you have done, and we want you to either retract them and then apologize and compensate us for the damages in which you have suffered, that's a completely different story. That's where the whole aspect of the ANC being a political party in the public arena, being subject to scrutiny as it happens on a regular basis in the public world, then that's where it's going to go in. But the two can't be mixed, because at the end of the day, you have to be accountable or be precise as to what you want to hold Mr. André de Ruyter to. If you are saying to him you did not go and open up those cases, then you must state, as per the law requires you to do so, you failed to do so. Hence, the law will then take its course, and those penalties and offences and the type of sanctions that are actioned by POCA, for example, which is the Prevention of Organized Crime Act, will then fall upon you. But if you attack him on the basis of defamation on a civil matter, there's a completely different matter, and the ways in which our courts have looked at it, they've said, we are not going to be blind to the level or to the element of freedom of speech. We are going to look into it, but however, in instances where we feel that you have crossed the Rubicon on the line of freedom of speech, that's when you're going to start to punish. But in instances where I'm stating your public opinion, which has been accepted, and also taking into account the type of person that you are talking about and the type of arena in which they play into, then we're not going to give you the satisfaction of that particular individual paying for it.
Still getting some analysis now following the North Gauteng High Court decision to grant the ANC the award to serve papers on André de Ruyter, who they are suing for defamation. Legal analyst Mpumelelo Zikalala still with us. And Mpumelelo, so we have learned, of course, in the last couple of days that there seemingly was a process that was a process that was led by André de Ruyter with some members of the private sector. They hired investigators, and these investigators uncovered all sorts of things around what was going on at Eskom. And this is that information that he went into this particular interview with, that he's now being sued for. Listen to what the BLSA leader, Busisiwe Mavuso, had to say on that particular investigation that they conducted.
This has been a successful intervention. I mean, it speaks to the fact that there were special working groups with the SAPS and the SIU, which were established at the back of the findings. It speaks to the fact that the President and Minister Gordhan have quoted information that are emanating from the reports. It speaks to the fact that valuable foreknowledge of strikes and protests of brewing civil unrest linked to criminal undertakings was provided. It speaks to the specifics regarding the magnitude of the corruption within the coal sector that were uncovered, due to the data that was collected. It speaks to the specifics relating to internal corruption at Eskom that were exposed. So, and I don't know if any of that features, in the information that is out there or the reports that have actually been put out there in the public domain.
So André de Ruyter's got 30 days to respond to the ANC, and could he use this as a defense to say, well, my interview was not defaming the ANC, but it was informed by information that even the president of the party and the minister, government official of the party, has quoted. The very same people have used this information to avert possible civil unrest that was brewing in the country. They are using this information right now to deal with internal corruption at Eskom. So how can this be defamation?
In fact, it is a defense. One of the defenses is that if the information or the defamation statements in which are being sued for is indeed true, and is also in the public interest, then I'm solidified or indemnified for any defamation action that can come against me. So Mr. de Ruyter's point or line could be similar to this one. Yes, as stated, I was simply relaying information which was available to me that links to members of the ANC being part and parcel of whatever criminality which has taken place within Eskom. I have credible information which has been available to me, but most importantly, don't forget that it is indeed true. And in fact, when I stated those particular statements, it was in the public interest because I was doing an interview where we were discussing issues of national importance. In instances where I had obligations to go and report on these matters, I did so in line with POCA, in line with PRECA. So when it comes to my legislative compliance initiative that I needed to do, I was able to do that as a CEO. If the court is acceptable or the court can be convinced that, yes, Mr. de Ruyter, you may have uttered words which are harmful or defame the ANC's character or integrity or respect when it comes to how people see it within the community, but you were speaking the truth, then there's no defamation case. But it would depend mostly on the sequence of events and the evidence in which both parties are going to level or provide at court.
Yeah. However, he seemed to have been a little bit more circumspect when he appeared before Scopa this time around and refused to outright name anybody in particular when it comes to this corruption. I don't know whether it was in anticipation of the fact that he could possibly be facing this defamation.
I do think so. Maybe it was a legal strategy from his side to say that I'm going to disclose my defense when it comes to this particular matter at a later stage, because as I've not been served with papers, they can come back or they can go and amend whatever they've written in their summons or their application. So I won't be able to provide a defense at a later stage. So let me play my cards closer to my chest. I'm not going to disclose the manner in which that information was then available to me or the accuracy or the truthfulness of the information that is there, which was a bit puzzling though, because when you have been called to Parliament, there are certain privileges that apply to you in the manner and the type of information that you ought to disclose. But most importantly, his allegiance as an African citizen, especially someone who was employed as the CEO as one of the parastatals, he's supposed to go and disclose everything that needs to be disclosed in our parliamentarians. If you do not trust the protection which are going to be provided to by Parliament, then who's going to provide better protection than our parliamentarians? Maybe to him he seems or he feels that he's much better protected if he goes through the legal processes of our courts rather than seeking protection from Parliament, which ought to receive every single information so that they're able to make better choices when they're thinking what is in the best interest of us as South Africans.
Does it matter who is bringing this defamation lawsuit? If, for example, I am being mentioned in my capacity as an anchor here on Newzroom Afrika, and my company decides, well, we are going to sue on your behalf, I don't necessarily do it. It's the ANC that's saying, well, you've defamed our officials in government. Can the ANC do that?
Yes, you can, because the interest in which you seek to protect, especially when it comes to defamation proceedings, is that you want to protect your integrity. You want to protect your good name when it comes to members of the public. So if you have a vested interest in your name being good, vested interest in your name not being tarnished in certain allegations which are not going to be true, then you have every right to go to court and seek that particular protection. But you must be very careful, because if you go to court and seek that protection, just make sure that whatever you're seeking protection from is not actually the truth. So our laws, what they say is that you can say something which is bad about Mpumelelo Zikalala as just as long as what you are saying which is bad is actually the truth or is in the public interest. That's where the defense is going to lie in when it comes to Mr. André. If whatever that was talking about is indeed true, whatever that was stating was indeed in the public interest, then he has a valid defense. No going to be punished in any manner.
How easy are these cases to win?
Let's say it's very difficult, because especially as a political party, the law is not oblivious, so it does not turn a blind eye to the type of character that you are in. So the more public, in the public eye or public figure you are, the more immunity or the more susceptible to criticisms or susceptible to insults, in which the court will then say, but you see, you are engaging in a process where public opinion, yes, does matter, but there are people who are going to throw slanderous comments against you. So you must learn to live with that, because we cannot protect you perpetually against it. There's also the right when it comes to public speech and to state whatever that you want to state, just as long as it does not infringe any other person's right. But if, as I've stated earlier, whatever which is being stated about you, it is actually the truth and is in the public interest, then there's no defense at all. That particular individual has every right, through their right to freedom of speech, to state those truthful facts, and also to state those truthful facts in the interest of the public.
Is it a regular thing that would happen in defamatory or defamation cases, where the party would just require or demand a retraction and apology? Because normally when you look at defamation, you're thinking that we're suing you for millions. Because why would I go to the process of going to court, even serving you? You're in Germany. I mean, it's a costly exercise that is costing me. And all I want from you is to say, I'm sorry, I retract what I said.
I think in this case, it's more of a case of a reputational management of the protection of the reputation of the African National Congress and nothing more. So they're not looking at it from a monetary perspective, because if you say you want to be paid certain damages that you have suffered, the onus is then on you as the litigant or the applicant to then say or the plaintiff to then say to court, due to those hurtful words that you have stated, due to the damaging reputation or damaging my reputation, I have suffered financial harm to an X amount. Now, in this case, how is the ANC going to prove that by utterances of Mr. André they suffered any amounts or any financial damages? They can't do that. And when you come to reputational management and maybe likes in which they would have received in next upcoming elections, it's going to be very difficult to try and prove this and convince the court if there's any damage or drop in the support in which the ANC would have received had Mr. André not uttered those words. So I think it's a matter of saying on a principal basis from the side of the ANC, we want to take you to court because you have stated certain things which are, in our opinion, are not truthful, and they are going to end up harming our reputation when you ought to have protected the parastatals that you were deployed or employed to make sure that you're able to protect and render services to South Africans. You failed to do that, and now you are simply attacking us with no unwarranted reason. And if the defense minister under Ruyter then says, yes, I may have stated things which we would not like to hear, certain things which would damage your reputation, but whatever that you were saying was actually the truth, then the ANC's cases would have fallen flat.
Here's another interesting one, because especially when it comes to these issues of suing and taking SOE representatives to court, he's going to say, well, I made those comments when I was the CEO at Eskom. Yes, they later got me fired. But is the state going to have to pay for this to protect André de Ruyter and defend him in court because he made those statements while he was CEO?
It would be a bit pushing it. And now I think they've refined the rules and regulations as to what to find when it comes to persons who are going to say, I was doing within the course and scope of my employment. So at that particular point in time, were you conducting that interview on behalf of Eskom, or you were conducting the interview on your own behalf on a private capacity? If it's on a private capacity, then you are not going to pay for anything that you have done. But if you're providing an interview on behalf of Eskom, only then you can come in and pay for your legal fees, because the thinking would be, why should I suffer for the sins of Eskom when I have done nothing wrong? If I was not employed as part of Eskom's official duties on that day, I wouldn't have a lawsuit which was going to be looking at me in my direction. So in this instance, I think that interview was done in his private capacity. He was doing it called only by him and nothing more. So he should be the one who's supposed to pay those legal fees. And the defense of Eskom would be, but why were you conducting interviews when we have a spokesperson who can be able to engage in those particular matters? Yes, there are instances in which you've spoken with the media, but the majority, we have someone who's solely tasked to make sure that they're able to deal with the media. You had no business in going and talking about these particular matters. Hence, we are not going to pay for legal fees in this instance.
Mpumelelo Zikalala, appreciate your time. Thanks so much for coming on and helping us through this analysis. That's legal analyst there, Mpumelelo Zikalala.